yes, oh yes, oh yes. The Honorable Supreme Court of the State of Texas is now in session pursuant to adjournment.
Thank you. Be seated. The orders of the court will be pronounced by Justice Spears.
Orders on causes. Harvey Donworth et Ux versus Preston 2 Chrysler Dodge, Inc. from Dallas County. The judgment of the Court of Appeals is reversed and the cause is remanded to that court. Opinion by Justice Spears. Concurring opinion by Chief Justice Phillips, joined by Justice Gonzalez and Justice Cook. Concurring opinion by Justice Ray, joined by Justice Mosey and Justice Hecht. Responsive Terminal Systems, Inc. versus Boy Scouts of America from Dallas County. Pursuant to Rule 133B, Texas Rules of Appellate Procedure, after granting the application for writ of error and without hearing oral argument, the majority of the court reverses the judgment of the Court of Appeals and remands the cause to that court. Per curiam opinion. H.W. Mitchell versus MKT Railroad Company from Fort Worth County. The judgment of the Court of Appeals is affirmed. Opinion by Justice Cook. Dissenting opinion by Justice Ray, joined by Justice Mosey and Justice Doggett. Dissenting opinion by Chief Justice Phillips to be delivered at a later date. The following motion for leave to file petition for writ of mandamus is overruled. Gary Lee Smith versus the Honorable Frank Sullivan, Judge from Tarrant County. Mr. Chief Justice, that completes the reading of the orders.
Thank you, Justice Spears. One cause has been set for oral submission this morning. It is Edgewood Independent School District and others versus William Kirby and others from Travis County. The court has allotted 55 minutes for petitioners to present oral argument, 1 hour for respondents to present oral argument, and 20 minutes for petitioners to present rebuttal argument. The proceedings today are being videotaped. This is an unusual procedure for our court. Let me explain why. These procedures are being videotaped by personnel of the State Bar of Texas at the request of the court. This videotaping is being done in conformity with Section A9C of Canon C of the Code of Judicial Conduct. The filming will not involve moving camera personnel or extra lighting to distract participants or impair the dignity of the proceedings. All parties have consented to the videotaping. There will be no exhibit of the videotape until after all appeals in this cause have been exhausted, and the videotape will be exhibited only for instructional purposes. The court is now ready to hear oral argument from petitioners in this cause.
May it please the court, Mr. Albert Kaufman will present first 35 minutes of argument for petitioners Edgewood ISD.
Good morning. We are here today to determine whether the Texas Constitution requires the legislature of Texas to treat people equally, especially to treat students equally, and to meet the legislature's constitutional duty to establish a suitable and efficient school finance system. I'm Al Kaufman with Mexican American Legal Defense Fund. We represent the plaintiffs' petitioners here. I'm joined by Mr. Richards and Mr. Gray representing plaintiff interveners. Altogether, we represent 68 school districts with about 400,000 students. Procedurally, this case was filed in May of 1984. An amended petition was filed in March of 1985. It was tried over a 10-week period with 8,000 pages of transcript, 40 witnesses, yards and yards of exhibits. Judgment was entered in June of 1987, where Judge Clark of Austin ordered the state to come up with a constitutional plan for the system of school finance by September of 1989, to begin the implementation of that plan in September 1990. The court, the defendants appealed that to the Court of Appeals. In December of 1980, the Court of Appeals found for the defendants, and we have perfected this appeal. That's why we're here today. As I said, we are here to discuss the future of the children of this state, and probably no more important issue will come before you in terms of the interpretation of our state constitution. The issues are, does the system created by the legislature guarantee equal rights, or does it give a set of men exclusive public privileges? Has the legislature met its mandatory duty to provide a suitable and efficient school finance system? Has the legislature denied privileges and immunities to the plaintiffs without due course of law? And can this court decide these issues? The defendants have challenged the power of this court to do so. In my argument, I'm going to outline first how the system works, how it affects human beings in the state. We'll look at the language of the Constitution to see what guidance that can give us in interpreting the legislature's actions. We'll look at the equal rights provision under Texas law and talk about your cases and other states' cases. We'll look at the efficiency and suitability of the system, due course of law, and the attorney's fees issues. First to the facts. The district court opinion in this case constitutes the facts of this case. Those facts were challenged somewhat in the Court of Appeals, but the Court of Appeals reversed none of them. So the facts found by the district court are the only ones before you today. In the district court's findings, of course, they are crucial, but in addition, you have to consider them in light of the district court's findings on the state's justifications for this discriminatory system as weighed against the interest of the plaintiffs. And under your case in TSEU in Texas of 1987, you determined that the state's justifications, the weighing of those against the interest of the plaintiffs, is a fact issue to be determined by the trial court. In this case, the trial court determined that this system of school finance is irrational. It's not efficient. It denies equal educational opportunity. That the denial of equal educational opportunity is not based on any rational consideration or policy. The district court determined that the system is not suitable, it's not adequate, and the state justification of local control is insufficient to rebut the interest of the plaintiffs and the suspect categories into which they fit. We're going to look at the system now as a whole, pointing out that the district court did exactly that. The district court looked at the system at the extremes and looked at the system in the middle. It looked at the system any way you want to cut it, and it found it discriminatory under each system. The state spends about $11 to $12 billion a year on schools in the state. 42% of that is paid directly by the state and 49% by local districts by the use of local property values. There are 1,060 districts in the state. 600 of them have less than 1,000 children. There are 3 million children in the state. The average wealth in a district is $250,000 per child. The importance of that, of course, is that that is the tax base on which local districts can provide an education for their children. That is what they go to, both to meet the mandates of the state and to provide whatever other educational offerings that they can. The average expenditure in the state was $3,300 at the time of the trial, and the average tax rate was 66 cents. In terms of wealth, the district... Excuse me.
We're talking about the students that are 85 to 86.
That's correct.
All these findings.
That's correct. The range of wealth at that time was from $20,000 a student in one district to $14 million a student in another district. But again, the district court didn't look just at the extremes. He said that if you look at 1 million kids here in the richer districts and 1 million kids there in the poor districts, these children have 2.5 times the wealth to draw on than the children over here. The state has classified human beings. The state has classified students into categories based on districts and has determined that these have much more access to the wealth of the state than do these.
Counsel, how does these facts changed or altered by the last legislative session funding for education?
They're really not altered at all. The system was a very small change in the last session. Didn't even meet inflation from 85-86. There are no major changes in the structure of the system at all, and an analysis of it shows that there's simply no changes to affect the issues before this court today. If we look at the 300,000 children at the very wealthiest districts, they have 25% of this state's wealth to draw on. The 300,000 here at the bottom have 3% of the wealth. In terms of expenditures, they also follow a similar range, from $2,100 a student in some district to $19,000 in another. But again, the district court did not look just at the extremes. He looked at this looking at the top 5% and the bottom 5%, the top 10 and the bottom 10, the top 20 and the bottom 20. And each comparison top to bottom, each comparison, the children in the poor districts suffered. They had less resources and their taxes are higher. In fact, the 150,000 kids in the richest districts have twice the expenditures as the 150,000 in the poorest districts. Now, in some of these issues today, we're going to talk about differences in expenditures of $100 or $200. That might seem minimal, but it's not, because $200 a student translates into $4,000 in a classroom, which means you can offer higher salaries, you can have more teachers, you can have more supplies and better buildings, even on $100 or $200 a student. When you're talking about the difference between $6,000 and $3,000, you can tell the difference in the provisions that a district can make for kids. In terms of taxes, the taxes in the poor districts are higher than in the wealthy districts. Often when someone sees this problem at first, they can say, well, the problem is people in the poor districts don't care enough about their kids. They don't raise their taxes. If they really cared, they'd raise them. In fact, they're higher. The poor districts pay higher taxes, and they get less for it, and they really have less incentive to raise their taxes than do the people in the wealthy districts. In terms of an $80,000 house, and this is in the record, if you live in Crystal City, you have an $80,000 house, you pay $1,100 a year taxes. If you live in Iran Sheffield, you pay $38 a year taxes. If you live in Iran Sheffield, you have 2 or 3 times as much spent on your children. Again, these children are all residents of the state of Texas. Our position is this is a state system of education. We have up before you the Constitution of the state of Texas, and it says that. It says it's the duty of the legislature. The legislature treats children differently, and it hurts the children. Now let's look a little bit at a combination of some of these factors. If you look at the 50 poorest districts, they average 72 cents tax and spend $2,900. If you look at the 50 richest districts, they have 37 cents tax and spend $8,700. Again, they're two different groups. To use the constitutional language, there is a set of men that has been given special privileges, special emoluments, and people are not given equal rights under the Constitution.
Counsel, just Judge Clark, in his opinion and findings of fact, defined adequate education as the educational program available to the 600,000 students in the wealthiest school districts. In other words, this should be the same standard as applied to all students. What sum of money would the legislature be required to appropriate to meet that standard?
That depends completely on the amount of the burden that they lay on the local school districts. If there's no change at all in the system, it would be a fairly expensive proposition. If you worked it out so that all of the people in the state shared equally in the burden, it would not be very expensive because you would not have the inefficiencies that you have in the present system.
Under the current system, what dollar amount are you talking about?
I don't have a complete figure. I know that the State Board of Education said that to have an adequate and equitable system would cost $5 billion for a biennium. But the figures that we have seen are much lower than that. But again, that is only if you continue the present inefficient system and expense anywhere like that be necessary.
Where is the inefficiency in the system as you see it?
The inefficiency is, I guess, at least 5 or 6 issues. First, in terms of the structure of districts, the legislature has created a system where one district pays 30 cents and gets as much as another district that pays $1.20. What that does is it does not allow the state to use the tax resources of that wealthy district. The district that's taxing at 30 cents and raising all that money is not taxing at the state average, is not bringing that money into the system. That's a waste of money. The formulas themselves are inefficient. $600 to $700 million is sent to richer districts that don't need it, and it's not sent to poor districts that do. At least two.
Is the answer in the legislature changing the formulas?
That's part of the answer. That would certainly help. We don't think long-term that will solve it. It's going to be a combination of a change in the formulas and a change in the way that the local districts are required to tax. Remember, it's the legislature's decision to put onto the local districts the burden of bringing their part of the system. The difficulty is that is raised by those local districts from districts of wildly varying tax wealth. That is an inefficient use of resources.
Well, is our job just to declare it unconstitutional if that's what we decide to do, or is our job also to tell the legislature how they ought to write the law?
Well, somewhere in between the two. First, your job, we think, is to declare it unconstitutional. To go farther, I think you have to declare that the system has to be efficient based on some of the major findings in the district court's opinion, that you cannot waste money through the formula system. You have to do something about districts that have tremendous advantages based on their local property wealth, and you have to look at the total efficiency of the system. This is not a new issue, by the way. Back in '49, when the Gilmer-Aiken bill passed, they said that the structure of this system is inefficient. In the Connolly Commission, chaired by Mr. Jaworski, they found the system wildly inefficient in terms of the use of resources. The evidence in this trial finds it inefficient.
So what you'd like for us to do is give them a hint about where it wouldn't be inefficient.
That would be very helpful. I think the district court did that. If you read the district court's opinion, there are many hints on where money was wasted in the present system, and that certainly would give the legislature guidance. We are not asking you to write a new school finance formula. We don't think it's your job.
Councilman, I thought.
I'm glad to hear you say that.
New Jersey, I think, had a similar problem. In New Jersey, or some of the state, 3 of the judges of the court were appointed overseers of the education system and became czars of education. That was one of the criticisms. Do you envision that for
No, we don't envision that at all, and that has not been the process in most of the states. That, by the way, only occurred after the legislature refused to move. To some extent, this is a relationship between the branches of our government. In other states, the Supreme Court has set a standard. The legislature has moved very quickly and come up with a system. That has been the end of the battle. In New Jersey, the legislature continued to say, we're not going to do it, we're not going to do it, we're not going to do it, and challenge the authority of the Supreme Court, and that's why they had to resort to those means. We don't see that happening here.
In some states, the plaintiffs have sued members of the legislature. The legislature is not a defendant in this cause. We therefore don't have a case in controversy with the legislature to require the legislature to do any particular deed. What remedy is justiciable that this court can order beyond ordering the State Board of Education and the comptroller not to allocate any state money whatsoever to education?
I think the limit of the court's authority ultimately is to say that the system is unconstitutional and that the comptroller and the treasurer and the state board cannot distribute funds. We are sure that given that, the legislature will respond. We do not see it as necessary to have them as parties and to threaten them with contempt of court. Hopefully we will not have that sort of...
But in essence, you're asking us to make things worse in the hope that another branch of government will make things better.
No. We're asking you to improve the system. We would think that any sort of order to stop sending funds is inconceivable, and our plaintiffs aren't going to pursue that. That, though, is the only position your court has. Under Ex parte Young, back in 1908, the Supreme Court said that we cannot tell people exactly what to do in the legislative branch. We can just say what's constitutional or not. We can say they can't spend money on our unconstitutional system. In the states, it's not been necessary in most of these states to have the legislature as a party. We would hope that before they would let Dr. Kirby and Mr. Bullock go to jail, the legislature would respond. Although Dr. Kirby might disagree with that, I don't know. But we don't see that we're going to get to that issue. And it hasn't happened in the other states.
Mr. Kaufman,
yes.
With regard to remedies in this area, as you know quite well, it was back in October of 1969 that 3 Texas federal judges gave the legislature another 2 years to do something about the school finance system. Even in concurring in rejecting the decision of those 3 Texas federal judges, Justice Stewart referred to our system as chaotic. There has been reference by Justice Gonzalez to the New Jersey cases where they've had Robinson 1, 2, 3, 4, and 5 in the New Jersey Supreme Court. Is the order of the trial court sufficiently specific to give the legislature the guidance it needs in order to get the job done and to prevent the necessity of repeated involvement by this court as happened in New Jersey?
The district court set a very clear, broad standard, but did not give details. And I think that was the proper course. Clearly, it would have made it possibly simpler if the district court had listed 10 principles that must be met. It's my understanding, and we don't recommend that he list those principles, just set a very definite standard. Our hope would be that if there's an affirmance of the district court standards, the legislature can read that, we can read that, we know what it means, that they will meet that standard. Certainly it would make it simpler for them if there were a list of 10 principles that must be met. But again, given the relationship among the branches, we do support the idea of a strong, clear statement first. If the legislature does not move forward, we might well have to come back and ask for a more detailed statement. It's going to depend on a good faith relationship between the branches.
Given the generation of children that have already gone through our schools during the time that this litigation and its predecessor case were pending, how quickly should we urge the legislature to act?
Well, the court order gave the legislature until September 1st, '89 to devise a new plan. That, of course, is unlikely given our present date. But it also said by 1990 the plan had to be implemented, and it needs to be done by then. Something has to be started no later than 1990. We would prefer an earlier resolution, some earlier interim relief. The State Board of Education about 4 months ago passed a resolution and said that the present system is leading to the financial ruin of school districts. We have several of our plaintiffs and plaintiff interveners who literally have no money left, and this time are faced with laying off teachers or reducing salaries, and will get worse next year. So we would hope for some immediate relief. The students starting now get out in the year 2000. So we would hope to, at least in the next century, to improve the system and improve our state at that level. In terms of the relationship among the districts and these tax rates, I think the story of North Forest is quite important in that they pay twice the tax rate of, almost twice the tax rate of Deer Park and spend 50% less. It also has a cycling effect. It is now more difficult for North Forest to attract industry, to attract businesses, because they have higher taxes and lower expenditures. So we are tied into the system, and that's one of the effects of the school finance system. In San Elizario, one of our plaintiffs, they have a $1.07 tax rate. They have no chemistry, no physics, calculus, foreign languages, pre-kindergarten, college prep, no extracurricular, no band, choir, football, no debate. They have 96% low-income students. Those students are not being given a chance in the society. The one more thing I want to do on the facts, I'm about to run out of time on the issue, is to explain to you briefly how the system works, the interaction of the local property wealth and the state funding. And I want to compare Edcouch-Elsa, a district of 4,000 students, and Highland Park, a district of 4,000 students. Edcouch-Elsa raises $2 a student for each penny tax rate. Highland Park raises $100 a student for each penny tax rate. If you have a 50-cent tax rate, then Highland Park raises $5,000. Edcouch-Elsa raises $100. Now, the state does give much more money to Edcouch-Elsa. It sends a check for more money. Edcouch-Elsa about $2,600, Highland Park around $300. When you add them together, though, Highland Park has $5,300, Edcouch-Elsa has $2,700, twice as much money at the same tax rate. But the importance is even further. And there is an issue of local control in this case. The defendants will make much of it. Let's talk about local control at the school board level. If this Supreme Court were a school board here, your superintendent, Mr. Vasquez, comes to you and speaks and says, we want a new problem for dropout, a new program for dropouts. It's going to cost $500 a student to have more tutors, more teachers, after-school programs, counselors with the students. If you are in Highland Park, you go to your superintendent comes to you as a school board, you ask him, how much is that going to cost in taxes? He says 5 cents. If you go to Edcouch-Elsa, you ask how much will this cost in taxes, he'll say $250. Now, which one of those boards has control? Which one of those boards can respond to the local populace? Which one of those boards can do something to help the people in their district? And the answer is fairly clear. Only the wealthy districts have that flexibility, that local control. Now, I've given you the extremes. Lawyers are often going to do that. The best case for the defendants is Edgewood versus Dallas. Even in that case, Edgewood spends less than Dallas in state and local funds, spends less. For Edgewood to spend as much as Dallas, they have to have a $1.30 tax rate against Dallas' 60 cents. But in addition, at a $1 tax rate, Dallas could spend $5,000. Edgewood could still only spend $3,200. So again, one has local control and one does not. I want to spend some time looking at the language of the Constitution because we think our case is so clear from it. First, if you look at the preamble to the Bill of Rights, it talks about the general, great, and essential principles. The word essential is important because it's the same word used in Article 1, Section 1, talking about the importance of education in our society. In the equal rights provision, there are two phrases there. One is a positive one is a negative one. One says all people have equal rights. The other says no set of men have special rights. If you look at this system, the children in low-wealth districts do not have equal rights. And what is worse, the people in the wealthiest districts have special privileges. And that has been instituted by the state legislature. Going on to Article 7, Section 1, there are 5 or 6 crucial phrases in that. The first one, a general diffusion of knowledge being essential to the preservation of the liberties and rights of the people. Extremely important phrase. We feel that it says from day one, we, the founders, the framers of the Texas Constitution, feel that education is crucial. Education is essential, is the word they use. The same word they use in the preamble of the Bill of Rights. They have stated from day one, this is what this state is about. As a matter of fact, it was one of the conditions for the entry of Texas into the Union was that they could continue an educational system. It goes on to say that it shall be the duty of the legislature. Crucial language. It doesn't say the duties on anyone else. It says the duties on the legislature to make suitable provision. Now, we're going to hear about Article 7, Section 3, another section of the Constitution, which gives the legislature the power to create school districts, the power to allow them to tax. Article 7, Section 3 does not say that local districts have the control of the school districts. It does not say that the state must allow them to tax. It says the state may allow them to tax.
Council, let's talk a little bit about this creation of school districts. How many school districts do we have in Texas at the turn of the century?
There are about 10,000 at the turn of the century.
And how many did we have at the time Gilmer-Aiken was passed in 1940?
I think it was around 1,500 or 1,600 at that time.
And we're now down to a little less than 1,100?
That's correct.
So the trend has been consistent since the turn of the century to reduce the number of school districts.
That is correct. However, under the present system, there still is a good deal of wasted money in terms of going to small and inefficient school districts as well as poor school districts. In addition, back in the Jaworski Committee report in the late 1960s, they suggested a system of about 350 to 400 districts. So in terms of efficiency related to the use of districts, it's a well-known issue in this state. But the trend is certainly going toward fewer districts. Yes, sir. Given my limited time, I want to really jump into the standards of equal protection that we have to apply here. I know that there are at least 3 ways that have been talked about in other courts and in this court. One is the strict scrutiny standard, one is the mid-level or middle tier standard, and one is rational basis. We feel we went under all 3. The facts, the undisputed facts of this case state that there are tremendous interest of the plaintiffs, there are classifications made that hurt them, and that the state's proffered excuses are not sufficient to justify the discrimination. But each one of these has some common things in it, and I think we need to talk about it. First, what are the classifications and what are the interests that are implicated by the system? The second is, what are the state's interests? Either the real interest as in statute or constitution, or even the ones that come up with in a court case. And the third is the degree of the relationship. In terms of the classifications, education is involved. Education was in the Texas Declaration of Independence. It's been in every Texas Constitution. It's essential to the rights and liberties of the people. The Court of Appeals in this case stressed that we don't say education is like other things. It certainly is very special and crucial to us. In terms of the classes, let's talk about the classes. These districts are separated out through the state system. Who lives in them? The concentration of people in the poorest districts are poor people and they're minority people. Most important thing is they are children. They have not done anything to deserve this system. Whatever you might want to visit upon their parents, saying that their parents could move or their parents could raise taxes. The children themselves are certainly innocent of any of this. They were born in a place, they're educated in a place, and they are consigned to the education that they get there under the state system. There are poor people in these districts, minorities, and disadvantaged. So those are the classes that are implicated here. What are the state's interests? The state's interest is in the Constitution. It says a general diffusion of knowledge is essential. The state must have an efficient system. The state legislature has passed a general law on state policy. It says the provision of education is a state responsibility, that they must have a thorough and efficient system. Excuse me.
You mean in the statute?
In the statute, that's correct. But those, as far as we can see, are the justifications for the state system. During the trial, they have come up with the idea of local control and that is implicated. The findings of the court, and I think the logic of the situation, is that local control is not compromised by an equalized system. And other Supreme Courts have said exactly that. They have said it is not going to reduce local control if all districts have the same rights.
Do you agree that a community can choose to tax itself more, to spend more on education than another community wants to?
Yes, I certainly do.
So you don't disagree that if a particular district in the state wanted to raise its own tax rate because it felt education was more important than another district, that it should have the right to do that?
I agree with that, and the district court specifically allowed that. The district court